being here. And so I am, as Victoria said, my name is John Whalen. I'm an attorney here in Albany. I've been practicing for about 20 years, 20 plus. I do a variety of matters, but do work with the Legal Aid Society quite often, and have done some estate planning for clients. I also do name change matters, and then some real estate work. And I have to add the disclaimer that Victoria added, which is that any opinions, views that I express are my own and not of my employer. But again, really happy to be here, excited. I think this is a great topic, and I think something that everybody should be aware of and learn about and understand that it really is for everyone, that estate planning is something that everyone should be familiar with, and try and figure out their own path, because it is very individual and something that I think is very valuable for every person and every community. So with that, I'll turn it back to you, Victoria.
Thank you. And we're envisioning this like a conversation, so we really do want to see your input and incorporate what you have to say. And with that, you have just segued into the first thing I wanted to say, John. When we were prepping for this, you said something that I really, really liked, which is that everyone has an estate plan, even if they don't have a will. Can you tell us a little bit about what you mean by that?
Yeah, so that idea is that everyone has possessions and or will have to make decisions at the end of life. And so either you have put those in writing and expressed your wishes through a will and or through what we call advance directives, which are healthcare proxies, living will, and a power of attorney, documents that tell others, how you wish to be treated. And then the will is basically the disposition of your assets. And so if you don't have those in writing, if you don't put those thoughts down, if you don't have that to show to that third party, there are statutes, and it's usually state, governed, that will control. And so whether you've determined what your estate plan is, or if you haven't, then the state is going to step in. And I think one of the points to get, across, which is really important, is that if you don't do it, it is very likely that the way that the state, and these are called intestacy statutes, that the way they distribute the assets is probably not going to be the way that you want it to be distributed. And so having the power to put this in place and put it in writing and have your wishes expressed really is something everybody should do. And just so, Victoria, so the idea is that everybody's got an estate plan. It's just whether they control it or someone else controls it. Because if you don't, something's going to happen, either with the will, where your assets get distributed via the statutes, the state statutes, and typically those, the way that works is either if you're married, it goes all to your spouse. If you're married with kids, part of it goes to your spouse and part goes to your kids. If you have no spouse and you have no children, they will then kind of drop down to, I think, either your parents or your brothers and sisters, things like that. And not everybody has a great relationship with their family members. And so whether you like it or not, your estate plan, if you don't put a will in place, may give your assets to someone that you don't really intend to give your assets to. So that's kind of the idea. The last thing I'm gonna, everybody knows Prince, the singer. Rest in peace. Phenomenal artist, and just an amazing, it was gave back to the community. But what Prince didn't do is he didn't have a will. And Prince wasn't married. He didn't have children. and think of the estate that Prince had. So he's got all of these recordings and things that, and a lot of assets, right? Way more than anybody, right? That we know and I have, or anyone. I mean, it's just, so this was an enormous estate. So he died, they call it intestate. So that means that he died without a will. And so they probated his estate. And what happened was people came out of the woodwork that weren't, had no relationship to Prince, half siblings, people he had never met. And guess what? They got part of his estate. They came out. And so that's an example of really the worst case scenario. I would imagine that Prince probably wouldn't have wanted that to happen, that he probably would have wanted his assets and the things that he had accumulated during his life, and especially his recordings, which go on after. I think they're releasing, albums. He had a vault of music that is enormous. And so I think they predict, I saw something, they're going to release an album every year for the next 50 years of Prince's music. And so this is something that, he probably didn't think about, didn't, really think, oh, I'm going to pass away anytime soon. But anyway, so that's, I think, is a real world case where, the unintended consequence came to fruition. Prince probably didn't want it to go to his half brother that he never met, right? So, so point is that to get it in writing, that way you can control it. That way where your assets are going. And then on the advanced directive point, you can appoint people who can take care of those decisions for you, medical decisions and other decisions.
And let me just ask you about the flip side of that. Obviously, as you say, we assume that Prince did not want people he had never met taking part of what he worked really hard to amass. Are there ever circumstances, and talking only about a will, not about a healthcare proxy, which we'll get to in a moment, are there ever circumstances where it doesn't make sense for someone to have a will, or where people can be comfortable without a will, or would you say everybody should have a will?
Yeah, it's a great question. I think it's in a very limited situation that you would not want a will. I don't think anyone, I'm going to say everyone should have one. I don't know of a case where it really wouldn't be a good idea to have a will. Everyone has something. We all have assets. We've accumulated things during our life. They may not be valuable. They may have sentimental value. They may have something, and you still want to make sure that those assets go to the people that you want them to go to. Otherwise, as I said, they get distributed via the state statutes, and usually that's not the way people want them distributed. I would say it's very limited. Offhand, I can't think of a situation where a person would not need a will. Anyone, if you're over 18, you've lived a life, you're going to want a will in place and recommend it for everyone. And the other thing is, what I'd say is, not a lot of people do have wills. That it's, I think the statistic, the latest, is that there's only 30% of adults in the United States have a will. And so that's far too low. And then the flip side is, I think the statistic is 80% think it's a good idea to have a will in place. So you've got that kind of tension between those two numbers, right? 30% actually do it, and then 80% think it's a good idea. So trying to get that, get that number, those two numbers to match. In other words, having people put a will in place. But I honestly, Victoria, I think it really, in all cases, I think it makes sense to have a will in place.
And let me go back to what you said just a second ago. I did not know that statistic. So essentially more than half of the people who think it's a good idea to have a will haven't done it, haven't gotten around to it. etc. Do you have a sense from your practice of what barriers there are? What are there specific reasons that come
Yeah, I mean,
that people?
that's another great question. I think it's individualistic. That probably because they think it's too expensive. They probably think that it takes too much time and effort when it really is fairly straightforward. In New York, it's very, I think, pretty straightforward, depending on the estate. If you have a very complex estate, then it takes more time and it'll take more money. 99% of the people have, it's pretty straightforward. And I would say there's a little bit of the idea that we're immortal, right? So we don't think of death. We don't want to think of those. Those are hard things to think about. It's hard to think about when you pass away, and especially in terms of, the advanced directives. So we talked about the will, but talking about the healthcare proxy and the living will, which have to do with healthcare decisions and sometimes end of life healthcare decisions. Those are hard topics to think about. And so I think there's a reluctance to maybe engage in those topics. So yeah, and I think that maybe they don't know how to go about it. What do you do? How do you start the process? And so I think a variety of reasons why people don't, Victoria. I think it's unfortunately, I think, and also when people hear it's a legal document, they think they do need a lawyer, and sometimes they do, sometimes they don't. So they kind of want to stay away. But I'm here to say it's a very straightforward process, and it really can be invaluable for everyone.
And I just want to, before we move on, I just want to highlight something you said a second ago. You said everyone over 18 should have a will. And we do tend to think of wills as something that you do, when you're older, when perhaps you start to fail, when you start to feel like, oh, maybe I'm not immortal after all. What are the reasons why people should have a will before that?
Well, yeah, because life changes, things change. And so you should probably, it may not make sense for someone who's 21 to, have a will in place. But if you get married, if you have kids, you do that early and you do that when you're young, certainly have a will in place. You want to make sure your spouse and your children are provided for, and that your assets go to them. They'll go to them, under the statutes probably, anyway, but you want to control that process. So, it, again, I mean, this is an individual, unique, determination. It depends on the circumstance, but, and I would say, I use the age 18 because that's the statute. It's only people over the age of 18 can create a valid will under New York state law. So, but I would say that it makes sense, given, certain circumstance. If you've got children, if you are married, and I'd say that the reason why is because in a will, you get to name your guardian. So if you pass away, you have the ability, through your will to determine who takes guardianship of your children. Without that, the court determines who your guardian will be of your minor children. And so to have that ability is really important, and make sure, that they're being taken care of by the people that you choose, not the state.
Thank you. So you've mentioned that the procedure a couple of times. You said it's a fairly straightforward procedure in New York. Can you tell us a little bit about how that unfolds? What happens when someone comes to you and says, hey, it's time for me to have a will?
Sure. So the first thing is to compile information. So this is a process where we want the client to sit down and think about, their family relationships, the assets that they have, and list those out and make sure that they're writing, a list of, okay, these are the assets that I have. This is how they're owned. In other words, how they're titled. Do I own them individually? Do I own them jointly with my spouse? For instance, in New York State, you can own property, individually, or you can own it with your spouse. And there are a couple of different ways you can own the property with your spouse. You can own it as a tenancy in common. You can own it jointly with your spouse, joint with right of survivorship. And then there's a tenancy by entirety. And so all those mean something. And so you would look to your deed. And so to see how that property is held. So there's paperwork. It's a lot of, I think, trying to, discover, how things are, how they're owned, what they own, listing them, and then getting into personal choice of how they want those assets distributed. And it really is a process, a long process before we can get to the point where we are putting that down into writing and putting it into a will. And then going through the advance directive, issue, which is the healthcare decisions and how you want, end of life healthcare decisions made. Do you want someone to make those decisions on your behalf? Do you want a DNR memorialized in the living will, DNR being a do not resuscitate? So that it's about getting information as much as possible, asking the right questions, having an interview. There's a sit down interview. There's a document that we give to clients that they fill out. And only then do we then sit down and put pen to paper, come up with an individual plan for those clients, and then, explain what the different documents do. So, what does a will do? So it can do a lot of different, it can distribute your assets. As I said, it, can name a guardian for your minor children. It'll name your executor, the person that's responsible for administering your estate through the probate process. So when you die, your will gets admitted to the surrogate's court, and then they, appoint the executor who's named in the will to act on your behalf and do everything under your will and administer your estate. So those are a few of the things that a will can do. Then there's the power of attorney, which is a document that is essentially you appoint an agent to act on your behalf related to, financial transactions, real estate transactions, other matters, banking transactions that you would not be able to do yourself. And so it's a very important document. So there's the power of attorney. And then there are the two advanced directives, the healthcare proxy and the living will. And so we'll sit down and explain all of those documents and what they do and whether they make sense for them. I've had clients that have only one. I've had clients that have had all these documents included, and documents with, or clients with only a few. So it all depends on their situation and their comfort level and what they want out of their estate plan. And as long as we communicate correctly and make sure that they understand, right, what they do and what they're, what they're comfortable with, then we proceed, and then we can get them in place.
Thank you. And can you tell us just a thumbnail view of what the procedure for actually getting the will signed is? I always feel like that sounds, it's called a will signing ceremony, right? And I always feel that sounds very, very fancy and very ritualistic and maybe a little bit off-putting.
Yeah, so it is a ceremony, and it can be. It doesn't have to be. And so the New York law, this is the section 3-2.1 of the state's powers and trust law. It's called the execution and attestation of wills and the formal requirements. I'm going to read a little bit here, and I hate to do that, but I'm going to read off of the statute because I think it's pretty well written. I'm not going to read the whole thing. It's very long, but it does say that the except for non-cupative and holographic wills authorized by another section, and those are essentially oral wills and handwritten wills. Every will must be in writing and executed and attested in the following manner. So again, in writing, typed, typed out, not handwritten. It shall be signed at the end thereof by the testator, or in the name of the testator by another person in their presence and by their direction, subject to the following. So what that means is that it needs to be signed by you, by the person creating the will, or the statute allows you, if you're not able to do so, you can direct someone else. And that's actually more common nowadays. You've got some, debilitating, illnesses where, people aren't physically able to sign things. So the law is caught up with that. And so New York State allows you to direct another person to sign on your behalf. So in writing, signed by the testator or someone on their behalf. And then the other important part is there shall be at least 2 attesting witnesses who shall, within one 30-day period, both attest to the signature. So the 2 witnesses need to be there and watch you sign. So you need two witnesses in the room. That's the ceremony. And then they need to sign it as well. What's interesting about the statute is they don't need to sign it immediately. They just need to sign it within 30 days, which is kind of an odd requirement in the statute. And that their addresses be in the will itself. So those are the kind of core elements of the ceremony and how it's done. So you would come in, it's a very straightforward, we would read the will as well. That's not necessarily a requirement, but I think it really is a good, idea to just make sure that everyone in the room is understanding what's going on. We're here to, sign the will of Victoria Esposito, and this is her last will and testament. These are her wishes for distributing her assets. We're here to sign it. Here are the witnesses. And so you sign, and then the witnesses sign. And then we have in New York, we do use a self-proving affidavit, which is essentially another signature. And it's that way that the circuits court just takes it and it proves itself. It's they don't have to call in the witnesses if there's some dispute that the will was not executed correctly. That affidavit essentially proves the will, proves the existence of the will. So that's in brief, that would be the kind of process of the ceremony.
Thank you so much. I always feel like it's important that people understand, this is not, it's not a scary thing. It really is not. And so now you've got the will signed. What do you recommend that people do with it physically?
Yeah, well, that's a great question. That's something, so the original should be kept in a safe place, of course. And depending on your comfort level, some people, don't want anyone to know about what's in the will. And so, in that case, that's more difficult because, you do want to communicate, to certain people the will's existence. And so you'll name an executor in your will. It's a good idea to tell the executor that they've been named, always a good idea, and tell them where your will is located. Maybe if you've had a lawyer, involved in the process, have the lawyer keep a copy. Lawyers nowadays in their offices probably, I think for the most part, don't want to keep the original in their office. Risk of destruction, things like that. And then there's, a good idea is keeping it probably in a safe deposit box or a kind of a vault in your house if you have one. A fireproof lockbox. Sorry, I mentioned the safe deposit box. That is not actually recommended, because what happens is when you die, the bank, if you've got a safe deposit box in a bank, they seal the safe deposit box. And so you've got this chicken and egg, problem that, it wouldn't be opened until your will is probated, but you don't have the will to go through probate. And so, so you want to probably keep it in your home, if possible, in a safe. I've heard of people putting it in there in a sealed envelope in their refrigerator, because it's a fireproof kind of appliance. So it's something. I think the idea is more telling people where it is and making sure people know where it is. So there are a variety of ways of proving it and making sure that you've got a copy, and the people that have the copy to submit to court when the time arises.
That is, I had never heard that about the refrigerator. It's basically like a poor man's fire safe. That's clever.
Yeah, exactly. Right. So now any documents, important documents, put them in your refrigerator, but make sure they're in a dry, proof, package. Don't make sure they don't get become part of your icebox.
Not in the butter drawer, for example.
Yeah.
So you mentioned a healthcare proxy, and you gave a pretty good overview of what a healthcare proxy is and does. Is there, in your opinion, who should have a healthcare proxy?
Yeah, I think everyone should have a healthcare proxy. It's not just for those that are ill or might be at older population. It's something for everyone. It is so the healthcare proxy will name an agent, much like the power of attorney, except it's for healthcare decisions versus financial or real estate decisions. But it acts in a very similar way. And so you name an agent who will make decisions for you if a doctor has determined that you are unable to make medical decisions for yourself. So that is a step that needs to take place. So the doctor needs to, and so what you would envision is you're unconscious or you have no, but that's not necessarily the case. That could be, you could have lost faculties, or you could be incapacitated in other ways while still being conscious. And so if a doctor does make that determination, so the agent will be your representative in those cases and dealing with your healthcare professionals to make health decisions on your behalf. So the really important thing about that is that you want to name someone who you completely trust, same as the power of attorney. So same as an agent that you would name for your financial, real estate, any other transactions under the power of attorney. Even more importantly, you want to make sure you've got someone you can trust who's making those healthcare decisions for you. And the other thing to note is you want to have discussions with them about how you want your healthcare handled. Most people, I think, wouldn't necessarily want the heroic medical measures at the end of life that may, if without a healthcare proxy, that may that hospitals and doctors because they've got the, kind of the Hippocratic oath and the, they're trying to maintain your, life. And so some people just don't want those, heroic measures. Remove a feeding tube, and so there are, things that you may not want the medical community to do on your behalf at the end of life. And so that's what the healthcare proxy is really meant to provide, that the agent really carries through your wishes. It's not their wishes. It's not how they feel. It's not, their, idea of, how it should be handled. It's your wishes, which you've communicated to them. This is how I want them that handled. And then there is the writing, which is the living will, which we combine. We put that within the healthcare proxy, and that can be very detailed, but not necessarily, but it does have some general parameters of, how you want your healthcare, handled at the end of life. There is the no extraordinary measures, no, if there's no chance of me regaining my capability so that I have a quality of life, then I don't want heroic measures done on my behalf. So the healthcare proxy, the biggest point of that is naming someone who you trust completely.
Thank you. And it sounds like that's a fairly simple procedure. It sounds like communication is really key with all the documents we're talking about. Would that be a fair statement?
Absolutely. Yes. So it's getting that, making sure that they're aware that they've given this authority to the agent. Very important. And then, that the power of attorney, the healthcare proxy, and the living will, understanding what they do and what they're, one of the things I should mention about the power of attorney is that goes into effect immediately. So it's a really powerful document. And so the person that you name is and in New York, what's most commonly executed is the durable power of attorney. There are other types. There's a springing power of attorney, which goes into effect at a certain time and event. But a durable power of attorney means you put it in place as soon as you sign that, and your agent accepts that appointment, and it continues through your disability, meaning durable. So it's a durable. So it operates all the way through until you die. And so so it's something that goes into effect immediately. That's one point that I think, people, I want to make sure that they understand that that's a power that they're giving to that person, immediately. Now, keep in mind that agent is subject to, ethical and fiduciary duties related to, acting on behalf of the principal. So they can't go out and use that power of attorney to do, anything that they want. They need to do it within, the guidelines and the ethics and for the benefit of the principal. And the other thing is, so that this is timely, this conversation, because New York made changes to the New York power of attorney law that went into effect on June 13th, 2021. And they're very important, and they changed it, the power of attorney pretty materially. So it basically simplified the requirements and the actual requirements of the power of attorney in the language, and relaxed the standards of acceptance. And so it's became it's more liberal in terms of, what will be, what by law should be accepted by third parties to whom you give that power of attorney. So there's still a statutory form, and we'd still use it, but now the standard is substantial compliance. The form needs to substantially comply with the statutory requirements, whereas before it was a strict adherence standard. And so, but I wanted to mention the New York power of attorney law. it did change, and so there are some new changes afoot that went into effect quite recently. So this is very timely.
Thank you. Good. So what you should do, what people should do, it sounds like, is make sure that their attorney is using the most current form. And that's perhaps a question people should know to ask.
You got it. Yeah, exactly. Make sure that they know that there's, they're new. And now the other thing to mention on that is that if you've got these documents in place, especially the power of attorney, if you've already got one executed, the new laws don't mean you have to go out and get a new one. You can. The other one is completely valid, completely acceptable, and should be, as long as it's valid, under the prior statute, should be fine and enforceable. So you don't need to run out and get a new power of attorney.
Excellent. And I have one more. You're mentioning changes in the law has reminded me of something. I know that during COVID, the governor allowed for remote will signing, remote power of attorney signing, that nature of thing. I have lost track of where the executive orders on that stand. I think we're up to executive order 202.200 and something. Is that still ongoing? And and I'm asking you to pull out your crystal ball here, but do you expect that will see remote signing of these documents continue?
It's a great question. I think the executive order, the latest one, is still in place, and I think you can still remotely have remote will signings. There's quite a complex procedure for it, and notarize, in order to notarize a document and things like that. Do I think it's going to be, something that they'll put in place? Probably. I don't. That's a really good question. I'm not going to make a prediction. I think I've learned my lesson on those. I think there are benefits to it, of course, but I think that this getting folks in the same room and having that done in the same room is probably, there is a very, beneficial aspect to that. But I would say it's worked. And so I would say there's a very good chance that that statute becomes permanent. That's probably a perfectly enforceable way to adopt and create a valid document through that procedure. I think it makes sense to do it, to have that ability, have that flexibility to do that remotely, just like remote work, just like everything we're doing. It really probably is something that probably will become a permanent fixture, something that we'll be doing going forward.
Thank you. And I'm sorry, that was a curveball. That wasn't a question we discussed, but I was thinking about the changes in the law that you were discussing, and that occurred to me as something that we really have seen over the last 14, 15 months. So I just wanted to get your take on it. Yeah.
And I think that it's a great, thank you. And I think it's something that, I think they're probably debating now, having the very discussion we're having of how that might happen and whether it makes sense to do it going forward. And I would think I would be an advocate of that. And I think it makes sense. People are working remotely. People aren't, traveling as much maybe. And so, so it gives flexibility, and it would give it, the argument is that it might make it easier for people to actually put in place a will or, some other document. So, having that ability and being flexible is really helpful and might make sense.
Excellent. Thank you. Now, I'm going to take you back to the power of attorney just real briefly. You mentioned that, so a healthcare proxy is for health decisions. A power of attorney is for, you said, financial and real estate decisions, business decisions, essentially, if you will. What if you have a power of attorney in place, but not a healthcare proxy? Can the power of attorney step in and make those decisions for your healthcare, or are those totally different animals?
Yeah, completely separate documents, completely separate, and the power of attorney, law in New York State, it only covers certain, categories. Healthcare decisions is not one of those categories, though the recent law did expand what an agent could do for certain healthcare things, like dealing with your doctor's office to get healthcare information under HIPAA. I think so that there's some broadening of what the agent can do under the power of attorney in terms of healthcare, but in terms of actual healthcare decisions, in terms of your care by a doctor, by a hospital, by a healthcare facility, that's through the healthcare proxy. That would not be through the power of attorney. So those are two separate documents. So the power of attorney would not give your agent, and you can't modify it so that it includes that. You've got to have the two different documents. Yeah, the recent changes in the law don't go so far as to give the agent the ability to, make those healthcare decisions on your behalf. So you would need a separate document for that.
Excellent, thank you. And one thing that I know people do sometimes is a disposition of remains
Yes.
form. What does that do, and why might people want to have one in place?
Yeah, so the public health law in New York State allows you to, and there's a form, and if anyone's interested, we can get that form out, and it's on the public health website, New York State website. It's a very short form. Again, same principles as here as the power of attorney healthcare proxy, is essentially naming someone else to act on your behalf and deal with the funeral home, if you have one, or whomever is responsible for your remains, to work with them to dispose of them according to your wishes and according to the document. So there's actually a document, it's called the disposition of remains, and it is something you would sign, and you would sign, and your agent would sign, and hand that to the funeral director, and they're bound to follow those directions. And why that's important is, you may not want, your family, right? So in absence of that, the funeral director is going to follow the directions of your spouse or your children or your close family members if you don't have a spouse or kids, and they may not be the people you want to, determine how your remains are disposed. And so, having, and the other reason to do it is because it settles disputes. You can have disputes over, how that, one child may think mom, wanted to be buried, and, another child thinks mom wanted to be cremated. And, they have this, dispute over how that, might work. And so getting it down in writing and have that, signed, and have someone who can act on your behalf is another very good idea. And that is another document that, would be part of an estate plan, something that, maybe something that you, depending on your wishes, depending on, and you can put language in the will, but because New York has this distinct form, it does make things a little bit easier, though it does add to the number of documents that we all kind of need to keep track of and put in the refrigerator. So, there's an actual form for that.
Excellent. Now, so you've got all your things in place. Sometimes life changes. People get divorced, people become estranged from family members, people may predecease them. What happens if you need to revoke your will or your healthcare proxy or your power of attorney?
Well, the easiest way to revoke is to adopt a new one, is to put another one in place and have a explicit kind of sentence and language in the document that says, I hereby revoke all prior either wills or healthcare proxies or powers of attorney. And so, that's really the way to do it, really, for the will. The power of attorney, same thing. I mean, you probably, you could revoke by telling someone that you've revoked it, and said, to tell the person, whom you've appointed as your agent under the healthcare proxy or the power of attorney, that I've revoked that. I'm no longer, I no longer want you as that person. And then probably just destroy it, right? And if you wanted to adopt a new one, then, do it, revoke, and then adopt a new document, and go through the same process, right? And make sure that you're doing it, in the same way. Yeah, one thing, so on this topic, I think it's related, is that, so New York is an elective share state. And so, meaning you can't, if you would not be able to disinherit a spouse, no matter what your will provides. So New York has a statute that pretty much, I mean, it talks about the surviving spouse being entitled to take either the larger of $50,000 or 1/3 of the deceased spouse's net estate. So it is, you can't disinherit your spouse, again, no matter what your will, without a formal agreement, unless you adopt a prenup or a postnup. And so, and I guess that the point of that is that if you are in a relationship and it's not, maybe not what you had hoped, and you want your spouse not to inherit your property, you'd probably, the best thing to do is get divorced. So it's probably that is probably the best way to make sure that your spouse does not receive your assets. So again, you can't do it through the will. You can't say, I hereby disinherit my, husband. You're going to have to actually go through the divorce process, because by statute, they would be, able to elect. They do have to go through a process to elect that share, but so that's a key component of New York's law.
Excellent. Thank you for the reminder. I really appreciate that. And I'm sure there are people who don't know that. And I suspect that's something that's going to be really useful. And in your opinion and in your experience, for LGBTQ individuals in particular, are there any considerations for estate planning that might be slightly different, or just need to be thought about a little bit differently, or anything that that is just a little bit more nuanced?
Yeah, I think it's similar. I think there are, some things that need to be, I think, going back to the intro and going back to what we stated at the beginning, that if you die unmarried and without a plan in place, the state law, default rules grant decision-making authority to your nearest living relatives and pass assets to those relatives. And so for LGBT community, especially those who might be estranged from their family, that can lead to unintended, results. So it really is important that, you have a will in place, you have some documents that dictate, how you want your estate administered, how you want your assets to pass. So I think but that's for everyone. But I think that's something to be aware of, and something that I think is, important to think about as you move forward and determine whether or not you want to put it in a estate plan in place. If you want the state to handle it, control your assets, and have essentially your relatives, you may want that. That may be perfectly fine. My guess is that that's probably not what most people want. They probably want their partner, to inherit and, receive their assets. And so the way to do that is to put a written will in place. Otherwise, you may have your assets, things that you've worked through your whole life for, go to people that you didn't really intend them to go to.
And does that hold true for healthcare proxies as well? What if someone does not have a healthcare proxy in place, but someone is going to have to, they're unfortunately incapacitated, and someone has to make that decision? Is that governed by statute as well? How is that done if you don't have that proxy in place?
Yeah, the doctors would look to the family and look to the closest family member. So that's that's another component, where, you'd want to name your partner, and have someone who you respect and trust, or not only your partner, but someone, a friend or someone else who can make those decisions. Otherwise, the doctors and the healthcare providers are probably going to go to your family and go to people, close relatives to make those decisions. So that is another aspect where, really valuable, to get that, take control, right? So this is all about empowerment. This is all about taking control of your, your assets, how they're distributed after, you pass, and healthcare decisions at the end of life. Otherwise, those are going to happen in a way, that you might not want them to. And so again, this is taking control. It's about protecting yourself. It's protecting the ones you love. And it's about empowerment. This is about taking control of that process.
And in that same light, I wonder if there are any particular considerations that domestic violence survivors ought to think about in terms of, after perhaps they've been able to get some distance or step away from a relationship. Is there anything that they perhaps need to think about in estate planning?
Same concept. If they're married, and that is, I would imagine, maybe that they don't want those assets or those decisions, if they've named their spouse, the abuser as, their power of attorney or healthcare proxy, they want to revisit their documents. And so that, and again, the elective share statute in New York, no matter what you do, if we put it into the will, hey, I don't want my estate to go to my, husband, they're still entitled to, their elective share. And so, I think that they should determine for themselves whether they want that to happen, and whether or not maybe a complete, legal divorce showing that, I'm no longer married to that person, and then the elective share is no longer an issue. That's essentially it would be null and void, but based on the divorce. And so they're similar for everyone, but I think that that's an important thing to consider.
Thank you so much, John. And I'm not seeing any questions, and we're coming in at just an hour, which I think is exactly perfect. So let me ask you this to leave people with. If the people watching walk away from this with only one thing, two at the most, but one or two things, what do you want that to be? What do you hope people walk away from this presentation remembering?
Well, we just discussed that about being in control of, taking control of your estate and your healthcare decisions. This is an extremely powerful area of the law. It's also a way that people can, dictate the way decisions are made. Unlike any other real area. So there are, this is a unique environment that I think that gives people, the ability to control the outcome. and have those decisions made and feel good about it. Think about it, make sure that the will does what you want it to do. You've named someone under your healthcare proxy or your living will and your power of attorney and all these documents. There's a level of comfort that can come from that. And so, and again, making sure that, the people around you are taken care of once you pass away. And we may not have assets to do that, but we might have things that we want to pass on to a grandchild or a niece or someone else that has sentimental value. And you want to do that through a document, and make sure that it gets to that person. So the takeaway is, be empowered, take control of this for yourself. And it's a very valuable way to, leave a legacy for your loved ones.
John, thank you so much for being here. Again, John Whalen, one of our local volunteers. He's an Albany area attorney. And he does, I want to say he does some wonderful volunteer work for us at Legal Aid, and we're very grateful to have him here tonight. Again, my name is Victoria Esposito. I'm with the Legal Aid Society of Northeastern New York. You can reach our office in Albany at 518-462-6765 if you need help with a will or any of the other civil legal matters we help with. And we hope to stream this live on Facebook. We had some technical difficulties, but we have been recording. And I'm hoping that we're available on our Facebook page sooner rather than later. Thank you for being here. And I am going to stop recording now.